స్టార్ట్ చేసేద్దామా? 10 minutes అయిపోయింది కదా.
స్టార్ట్ చేయండి, ఈ లోపల జాయిన్ అవుతారు కదా వాళ్ళు.
అవును సార్, అవును. Okay, sir. So we'll go with the fifth topic in BNS, which is basically criminal conspiracy. Criminal conspiracy definition in section 120A IPC. Criminal conspiracy defined when two or more persons agree to do or cause to be done an illegal act in which not illegal by illegal means. Such agreement is designated a criminal conspiracy. Such an agreement by two or more persons to do illegal act on an act by illegal means is criminal conspiracy. So two or more people undali illegal act చేద్దామని అగ్రిమెంట్ చేసుకోవాలన్నమాట. So that's what is that's what is criminal conspiracy. Then section 120B, punishment for criminal conspiracy, where the conspiracy is to commit a serious offense punishable with death, life imprisonment, or rigorous punishment is greater than 2 years. And same punishment as abetting that offense. So typically, I think ఇవి క్రిమినల్ కేసెస్లో ఎలా రాస్తారంటే, ఇప్పుడు కిడ్నాపింగ్, మర్డరు, ఇవి అయినప్పుడు దే సే సెక్షన్ 376 రెడ్ విత్ సెక్షన్ 120B. అంటే ఇప్పుడు 4-5 కలిసి కిడ్నాప్ చేశారనుకోండి, సో వాళ్ళ మీద ఎఫ్ఐఆర్లో ఇలా వస్తుంది అనమాట. సెక్షన్ 376 రెడ్ విత్ 120B పనిష్మెంట్ ఫర్ క్రిమినల్. సో బేసికలీ కాన్స్పిరసీ మల్టిపుల్ పీపుల్ చేసినప్పుడు ఇది వస్తుంది అనమాట. సో డిస్టింక్షన్ ఫ్రమ్ అబెట్మెంట్. సో హౌ ఈజ్ ఇట్ సో అబెట్మెంట్కి కాన్స్పిరసీకి ఏంటి తేడా? అబెట్మెంట్ అంటే కెన్ బి ఎ పర్సన్ అలోన్, need not be an agreement, and act need not follow. So covers past, present, future encouragement. Criminal ఏంటంటే requires two or more persons. Conspiracy లో agreement is essential. Mere agreement is the offense. Agreement at the moment of conspiracy. Okay. So this అబెట్మెంట్ కి కన్స్పిరసీకి ఇదండి తేడా. సో అబెట్మెంట్ కి 1 person ఉంటాడు. అబెట్మెంట్ కెన్ బి పాస్ట్, ప్రెసెంట్ అండ్ ఫ్యూచర్. కన్స్పిరసీ ఈజ్ ఆల్ అబౌట్ ఇద్దరు కలిసి అగ్రీ చేయటం దట్ వీ విల్ డూ దిస్ క్రైమ్ అని. సో దిస్ ఇస్ 128 అండ్ 120B. సో వాట్ ఈస్ ద డిఫరెన్స్? 120 is criminal conspiracy, two or more persons, illegal act. 120B is of course the punishment. So criminal conspiracy చేసిన వాళ్ళకి ఏంటి పనిష్మెంట్ అనేది 6 months to 2 years అనేది చెప్పారనమాట. సో దిస్ ఈజ్ అలాంగ్ విత్ ద ఒరిజినల్ క్రైమ్. సో దట్ మీ కిడ్నాపింగ్కి ఫర్ ఎగ్జాంపుల్ 4 years పడితే దీనికి ప్లస్ ఈ సెక్షన్కి అనదర్ 6 months పడదు. సో డిస్టింక్షన్ అబెట్మెంట్ కాన్స్పిరసీ గ్రేటర్ దెన్ 2 persons ప్లస్ అగ్రిమెంట్. ఇంపార్టెంట్ థింగ్ ఇస్ గ్రేటర్ దెన్ 2 persons అగ్రిమెంట్ ఉండాలి. సో లాస్ట్ ఇయర్ 13 AIBE 13లో క్వశ్చన్ అడిగారు, when 2 or more persons agree to do an illegal act or an act in which not by illegal means, such an agreement is designated as what? So such a day, so one agreement ఉంది, 2 or more people ఉన్నారు. సో ఇల్లీగల్గా వాళ్ళు దే ఆర్ మేకింగ్ అన్ అగ్రిమెంట్. దట్ ఈస్ నథింగ్ బట్ criminal conspiracy. The answer is C. So offenses against state. So next topic is basically offenses against state, which is 4.6. 4.6 లో ఏంటంటే the first thing is waging a war against government, section 121 IPC. Waging a war against government of India or attempting to wage war, abetting war or war. Maximum punishment is death sentence. So alternate punishment is imprisonment for life plus fine. So the important thing ఏంటంటే if you wage a war against the government, the maximum punishment will be death, or you can have imprisonment for life. Okay. So I think this is a section in which that JNU, one guy is there in the jail and they're trying to get his bail and he's being rejected. One of the sections they put was basically section 121 and I think 124A they put. Another thing is section 4.6.2 sedition, that is section 124A. Whoever by word, signs, visible representation, or otherwise brings or attempts to bring into hard or contempt or excites or attempts to excite dissatisfaction towards the government established by law shall be punished with imprisonment for life, imprisonment up to 2 years, and fine alone. So Mahatma Gandhi was prosecuted in 1920 under section 124 for sedition and disaffection for government. So since IPC came into existence before our independence, Mahatma Gandhi was prosecuted under the section. These sedition cases, Queen Empresses was Bal Gangadhar Tilak 1896.
ఇప్పుడు సెడిషన్ ఇందులో బిఎన్ఎస్ లో తీసేసారేమో.
బిఎన్ఎస్ లో లేదు, కరెక్ట్. బట్ మనము రెండు చదవాలి కదా.
రెండు చదవాలి.
So అందుకని. So actually BNS does not retain section 124 sedition, replaced it by 152, which is acts endangering sovereignty, unity, integrity, security of India. తీసేసినా కానీ ద కాంటెంట్
వేరేగా పెట్టారు.
సో ఇవి 3 ల్యాండ్మార్క్ కేసెస్. బాల్ గంగాధర్ తిలక్ ఫస్ట్ ప్రాసిక్యూషన్, సెకండ్ ప్రాసిక్యూషన్, అండ్ నిహార్ దత్ మజుందార్ వర్సెస్ ఎంపరర్ 1942. ఓకే. In May 2020, the Supreme Court, Mohammed Tarke versus Union, stayed all pending prosecution under Section 125 pending reconsideration. So the BNS 22 does not retain Section 124 as sedition, replaced by acts endangering sovereignty, unity, integrity, and security of India. Because the Supreme Court case anni stay చేసింది కాబట్టి 2023 when the BNS came, they tried to change అన్నమాట. నెక్స్ట్ ఎగ్జామ్ టిప్స్ వచ్చేసి సెక్షన్ 121 వేజింగ్ వార్ మ్యాక్సిమం పనిష్మెంట్ ఇస్ డెత్. 124 సెడిషన్ బ్రింగ్స్ హేట్రెడ్ కాంటెంట్. గాంధీ కేసు ఒకటి గుర్తుంచుకోవాలి 1922 సెక్షన్ 124A ప్రకారం. అండ్ కీ సెడిషన్ కేసెస్ ఒకటి. సో the question was Mahatma Gandhi was jailed and prosecuted British in 1922 under which section 124, and sedition. Maximum punishment for waging war against government of India under IPC is what? Maximum punishment is death sentence. And which of the following case is the following case? The offense of sedition was an issue. The offense of sedition was an issue. Queen Bal Gangadhar Tilak Majumdar case lo kuda undi. And this Kedarnath, the state of Supreme Court, by upholding the constitution was, so I think in all of the above. And the provisions regarding sedition are given in, it's given in section 124A of IPC. And offenses against public tranquility. So basically unlawful assembly, 141, assembly of 5 or more persons in unlawful assembly, if the common object is overthrow government to resist the execution of law and legal process, to commit mischief, to obtain prosecution, to compel any person to do illegality. Every member of unlawful is guilty of an offense under section 143C IPC. So next to unlawful assembly, next is affray. Affray is given in section 159. Affray means when 2 or more persons by fighting in public place disturb the public peace, they are said to commit an affray. So punishment under section 160, imprisonment up to 1 month or fine up to 100 or both. Okay. Next, promoting enmity but among groups. So section 153, promoting enmity between different groups, religion, race, place of birth, residence, language. Okay, so exam tested idi. And deliberate outrage of religious feelings, section 295, deliberate and malicious acts intended to outrage religious feelings by insulting its religion or religious beliefs, uttering words with deliberate intent to wound religious sentiments, section 298. And the difference in 295 ki 298 ki 295 is deliberate acts. 298 is uttering words and what. That is a difference. And then adulteration of food. Section 272, adulteration of food and drink intended for sale. Section 273, sale of noxious food or drink. So adulteration of food is punishable, which is 272 and 273. So we come back to the questions they have asked. If when two or more persons by fighting a public place disturb the public the public peace, they are said to commit what? They are said to commit an affray. So what is an affray? Affray is when two or more persons by fighting in public place disturb the public peace. Next, deliberate and malicious intent, intended to outrage religious feelings in any class by insulting its religion. Religion is an offense under 295A. Uttering of words with deliberate intention to wound religious sentiments. Words, such as, see, there's a difference, right? There are two sections. Words is 298 and actions is 295. So it's 298. Uttering of words is 298. Right. Uttering a word, deliberate intention of word religions and dealt with. As per the key, there is 298 option C. Okay. Basically, revision kilo D అని చెప్పారంట, but answer is basically 298A కదా. Okay. Promotion of class hatred is given under class hatred 155(3) on grounds of religion, caste, creed, birth, or doing acts prejudicial to maintenance of harmony, which is under section 153A of CPC. Adulteration of food to 272 to 273. That is in question 5. And yeah, broadly, these are the things. And the second one is offenses by and against public servants. So in this section, offenses by and against public servants are in section 161 and to 171 of IPC. So what does section 161 to 165A of IPC ఏమని చెప్తుందంటే public servants taking gratification bribes have been repealed and replaced by Prevention of Corruption Act. So ఇవి 161 to 165 తీసేశారనమాట, Prevention of Corruption Act లో పెట్టారు. Next, election offenses. Election offenses, section 171A of IPC, not part of the original IPC. They were introduced by subsequent amendment. Next, harboring an offender. Section 212, harboring an offender. Section 216, harboring an offender who has escaped from custody. And section 216A, harboring an offender in a case punishable with death or imprisonment of life. So 216 to 216A. 216A is much more serious. When death penalty not తప్పించుకున్నప్పుడు వాడిని help చేస్తుంది. So recently, I think harboring an offender. So I think ఇప్పుడు ఈ Nida Khan case లో it will be just 212 because she didn't escape from custody. So they cannot apply 216 on that, I guess. Next, questions related to this is offenses related to elections are where election లో చేసిన offenses IPC లోనే ఉన్నాయి. Okay. They are introduced in IPC by subsequent amendment. IPC లోనే amendment చేసి introduce చేశారు. Next, to harboring an offender who escaped from custody or whose apprehension has been ordered, if the offense be capital is dealt under. Okay, capital punishment అయితే it is basically 216. 216 216A ఉంది. That's what it is. And read the following statement and choose the correct option. Under the IPC, if a person harbors an offender who has escaped custody for an offense of punishment with imprisonment up to 3 years, he shall be punished with imprisonment up to 7 years. The law provides an exception for harboring or concealing by the husband or wife of an offender. In the context of the above statements under Indian Penal Code, which of the following is correct? So the first ఏంటంటే if the person harbors has escaped, సో 3 years పనిష్మెంట్ ఉన్నోడిని హార్బర్ చేస్తే వాడికి 7 years పనిష్మెంట్ పడుతుంది అని చెప్తున్నారు. దట్ ఈస్ నాట్ కరెక్ట్. కామన్ సెన్స్ వైజ్ ఆల్సో ఇట్ డజంట్ మేక్ ఎనీ సెన్స్. సెకండ్ ఈస్ ద లా ప్రొవైడ్స్ అన్ ఎక్సెప్షన్ ఫర్ హార్బరింగ్ ఆర్ కన్సీలింగ్. హస్బెండ్ ఆర్ వైఫ్ అయితే ఆబ్వియస్లీ దే వాళ్ళు లా కన్నా ఎక్కువ దే విల్ ప్రొటెక్ట్ దెమ్. సో ద లా హెస్ గివెన్ అన్ ఎక్సెప్షన్ ఎక్సెప్ట్ ఫర్ హస్బెండ్ ఆర్ వైఫ్ harboring or concealing. So statement 2 is true. 1 is not true. This is asked last year. So last year the paper was very tough. So you have to use your brain to uh, find the answers on that. Okay, so we'll move on to the next part, which is basically offenses against human body. This is the heaviest chapter. 22 previous year questions ఉన్నాయి ఇందులో. It converts homicide, grievous hurt, assault, force, and related offenses. So homicide means the killing of one human being by another human being. Okay, homicide may be lawful, unlawful. Lawful అంటే justifiable execution under court order or private defense, and unlawful is culpable homicide or murder. So culpable homicide ఏంటంటే the distinction is among the most tested areas. Section 299, culpable homicide, whoever causes death by act with the intention of causing death, an act with the intention of causing such body ranges as is likely to cause death, an act done with the knowledge that is likely to cause death. సో ఇక్కడ ఏంటంటే లైక్లీ టు కాజ్ డెత్, ఇక్కడ ఇంకా డెత్ అవ్వలేదు, likely to cause death. So section 300 is murder. Culpable homicide is murder if done with intention of causing death or done with intention to cause bodily harm, injury that offender knows to be likely cause death. Done with an intention that the bodily injury is sufficient, done with the knowledge that the act is so imminently dangerous that it must be all probability cause death. So the classic comparison is Reg versus Govinda. Melville J. Judge set out the comparative table distinguishing between culpable homicide from murder. The real distinction between section was made clear by Melville J. in Reg versus Govinda case in 1876. Okay, explanation is basically the cause of death of a child in mother's womb is not homicide. Okay, culpable homicide not mounting to murder. The 5 exceptions are as 300 is basically grave and sudden provocation, private defense, exercise of public function, consent, trivial act causing death. So 5 exceptions ఉంటాయి. Murder, grave and sudden provocation చేశారు, ప్రైవేట్ డిఫెన్స్ లో చేశారు, ఎక్సర్సైజ్ ఆఫ్ పబ్లిక్ ఫంక్షన్స్, కన్సెంట్, ట్రివియల్ యాక్ట్ కాజింగ్ డెత్, రెడ్యూస్ మర్డర్ టు కల్పబుల్ మర్డర్ నాట్ అమౌంటింగ్ టు మర్డర్. సో పనిషబుల్ అండర్ సెక్షన్ 304. Okay. And so Amit illustration and Amit intending to cause death attacks Vijay with knife. Vijay sustains several injuries and dies later. Culpable homicide not amounting to murder under section 304. Note here the answer turns on precise facts with full intention to cause death. It was ordinarily, but the BC has replaced it to 304. Okay. So బీసీఏ ఆన్సర్స్ మీద మనం కాన్సెప్ట్స్ చదువుకోలేం కదా. వాడు ఇంటెన్షన్ టు డెత్, వాడు చంపేయాలనుకున్నప్పుడు ఇట్ ఈస్ బేసిక్లీ మర్డరే అవుతుంది. 300 సెక్షన్ 300 పెట్టాలి. నెక్స్ట్ కాజింగ్ డెత్ బై నెగ్లిజెన్స్ 304A, కాజింగ్ డెత్ బై ర్యాష్ ఆర్ నెగ్లిజెంట్ యాక్ట్ నాట్ అమౌంటింగ్ టు కల్పబుల్ హోమిసైడ్. సో imprisonment up to 2 years or more. Professional negligence against medical profession is often invoked under section 304. So this is where doctors are booked అనమాట 304A సెక్షన్ ప్రకారం, విచ్ ఈస్ బేసికలీ ప్రొఫెషనల్ నెగ్లిజెన్స్ వలన వాడు చచ్చిపోయాడు. Abatement of suicide already covered in 4.4. Reiterated section 3 is abatement of suicide. And then infanticide, section 315, act done with intent to prevent a child from being born alive or it to die after birth. Designed specifically to curb infanticide. Okay, So I think there must be some distinction here on how you differentiate it between abortion and this. But after birth also, if you try to kill the baby, it is called infanticide. Before birth, I think it's maybe after 5 months or 7 months. We have to know the exact this thing. Next, acid attack, 326A and 326B, voluntarily causing grievous hurt, use of acid, voluntary throwing or attempting to throw acid, punishment. So A is about what the
Sir,
act is.
uh, sir,
Yes, ma.
just a small thing. Abortion ante before it uh, for in the child, not the fetus, actually fetus, before it comes out, out of, before it is delivered, basically that is abortion. Infanticide and killing of a child less than 3 days.
Okay.
Less than 3 days ఉంటే అప్పుడు దాని ఇన్ఫాంటిసైడ్ అంటారు.
To die after
I
birth.
read it somewhere.
Okay.
Yeah, it's after birth. It's after birth. Child is fully alive, delivered. Kani, it is less than 3 days.
Okay.
Child is killed. Infanticide.
Yeah, female చంపేస్తారు అదే కదా.
Something would have started like that. Abortion ante not yet delivered. Ante.
Yeah.
Yeah, I just wanted to say that. It's okay.
Okay. We'll check that and then maybe tomorrow we'll talk. All right, so moving on to the next one, which is basically the Justice J.S. Verma Committee was constituted in December 2000 following a Nirbhaya gang rape case. It led to the criminal law amendment, which amended the IPC sections 354, 326, 376, CRPC provisions, and IEA and IEA. So, ఇది ఏంటంటే 354, 326, 376 ప్రొవిజన్స్ యాడ్ చేశారు. సిఆర్పిసిలో కూడా 154 ప్రొవిజన్ యాడ్ చేశారు. అండ్ నెక్స్ట్ ఏంటంటే రేప్ ప్రొవిజన్స్ బిఎన్ఎస్లో కొత్తగా వచ్చింది ఏంటంటే సెక్షన్ 64 పనిష్మెంట్ ఆఫ్ రేప్ ఈక్వల్ టు సెక్షన్ 376 అండ్ సెక్షన్ 65 ఎన్హాన్స్ పనిష్మెంట్ ఫర్ రేప్ ఆఫ్ ఉమెన్ బిలో 16 years or 12 years. ఇది ఐపీసీలో లేదు. సెక్షన్ 70 is gang rape provisions including death penalty for gang rape of minor. Okay, this is there. So 64, 65, 70 in BNSS ఇవి యాడ్ చేశారు అన్నమాట. And then outraging modesty, section 354, assault or criminal force to a woman with intent to outrage her modesty. So basically cognizable and non-bailable. Rupa Bajaj was a KPS Gill, famous case where KPS Gill, Director General of Punjab, was held guilty under Section 354 for outraging the modesty of Rupa Bajaj, an IAS officer. Okay, kidnapping, maiming minor for begging. Okay, so basically Section 363, kidnapping and kidnap చేసి and begging ki force చేస్తే whoever meams any minor in order that such minor may be employed, imprisonment for life and fine. And wrongful restraint, wrongful confinement, the section 339, wrongful restraint, obstructing a person from proceeding in any direction in which is the right to proceed, and 340 is wrongful confinement, wrongfully restraining in person in such a manner to prevent him from proceeding beyond certain circumscribed limits. Okay, so A places men with firearms at the outlet of a building and tells Z that they will fire at Z if Z attempts to leave. This keeps Z within the circumscribed limits. That is wrongful confinement. Okay. And criminal force. Section 350. Whoever intentionally uses force to any without that person's consent in order to cause injury, fear, and annoyance is criminal force. A incites a dog to spring upon Z without Z's consent intended to cause injury, fear, and annoyance. That is criminal force. So under BNS 2023, criminal force is a force used intentionally without consent and with the intent to cause injury, fear, and annoyance. The same essentials as IPC 350 and think దీని సెక్షన్ రాయటం మర్చిపోయినట్టు BNS లో ఏ సెక్షన్ చూడాలి. ఓకే, నెక్స్ట్ చైన్ స్నాచింగ్ అనుకుంటా, విచ్ ఇస్ ద న్యూ BNS offense. Section 305 introduced చేశారు. Defines offense of a new introduction IPC, not there in IPC. 304 ఒకటి లేదు. So in Rupa Bajaj versus KPS Gill, in the famous case, the Supreme Court decided on what? Outrage of the modesty of woman. She was an IAS officer, and outrage of modesty of woman is punishable under which section? Which is section 354. The distinction between 299 and 300 was made by Melvis J. In which case? In Govinda versus Reg versus Govinda. Okay. ఇది స్మార్ట్గా ఎలా రాశాడంటే రెగ్ వర్సెస్ గోవిందానా గోవింద వర్సెస్ రెగ్గా అని అడిగాడు. సో ఐ థింక్ ఇట్ ఈస్ రెగ్ వర్సెస్ గోవింద. సో జస్ట్ ఇది మన బేరాక్స్లో ఉండవు కాబట్టి ఈ కేస్ నేమ్స్ గుర్తుంచుకుంటాం, ఇంపార్టెంట్. What is meant by homicide? Suicide by human being not at home, suicide at home, killing a human by another human being, killing of human being by an animal. So killing of human by another. So abetment basically. But what is meant by homicide? Suicide by human being not at home, suicide at home. Suicide is not homicide here. Killing a human being, another human being. That's what it is. Simple thing. Killing a human being by animal is also not homicide. So A places men with firearms at outlets of and tells Z that if Z goes, he will be fired. So it will be wrongful restrainment or wrongful confinement. So the illustration is 340, wrongful confinement by placing armed men. A keeps within circumscribed limits, which constitutes wrongful confinement under section 350. So yeah, answer is actually wrongful confinement, not wrongful restrainment. Because we are confined into a circumscribed limits. So answer will be B. And A incites a dog to spring upon Z without Z's consent. A intends to cause injury, fear, or annoyance to Z. So this is called criminal force. A uses criminal force on Z or not. Which of the following section is designed to curb infanticide? Section 315 of IPC. What does it say? Penalize any action with intent to prevent a child from being born alive or cause it to die after birth. Designed specifically to curb infanticide. Section 317 deals with exposure, abandonment of child under 12. Section 313 deals with miscarriage without consent. Section 318 with concealment of birth by secret disposal of dead body and all these things. And AIBE 14. A places men with firearms at the outlet. Again same repeat question. No? కానీ ఇందులో బోత్ అంటున్నారు, రిస్ట్రైన్మెంట్, రాంగ్ఫుల్ కన్ఫైన్మెంట్, రిస్ట్రైన్మెంట్, బట్ అల్టిమేట్లీ ఇట్ ఈస్ రాంగ్ఫుల్ కన్ఫైన్మెంట్. ఓకే, ఏ ఇన్సైడ్స్ డాక్టర్. ఓకే, ఇన్ రిపీట్ క్వశ్చన్ సేమ్ థింగ్. Voluntary throwing or attempting to throw acid is punishable under what act? Voluntary is section 326. Okay, section 326 is acid చేస్తారు. దాని ఈక్వలెంట్ is section 124 of BNS. Under which section of IPC professional negligence is often invoked against medical professionals in case of alleged professional negligence, which is 304A. And the committee which led to the passing of criminal law was headed by Justice J.S. Verma after the Nirbhaya case. Causing the death of child in mother's womb is not homicide as provided under. Causing the death of child in mother's womb is not homicide. Why it is not homicide? Under section 299 explanation 3 of section 299, it says defines culpable homicide clarifies that the cause of death of a child is the mother's home, not homicide, but it may amount to culpable homicide to cause of death of a living child if any being brought forth, even if it is not birth or completely born. Yeah, so BNS is equivalent to section 100. I think the section 299 gurinchi we should have some clarification, because how does it differentiate with abortion is very important. But it may amount to culpable homicide to cause the death of a living child if any of is brought forth, even if it is not breathed or completely born. Point clarity all man. Okay, next, assault of criminal force to women with intent to outrage or modesty under IPC is which kind, which is cognizable and non-bailable. Okay, so these are cognizable offenses and they're non-bailable or not. A places men with firearms, again ఈ చాలా సార్లు అడిగాడు ఈ question. So the answer is both wrongful confinement, wrongful restraint అంటున్నారు. The illustration wrongful confinement every year ఒక ఈ బార్ ఎగ్జామ్ కూడా ఎవ్రీ ఇయర్ ఒకటి కరెక్ట్ అని చెప్పాడు. ఒకసారి ఏమో రాంగ్ఫుల్ రిస్ట్రైన్ కరెక్ట్ అంటాడు, ఒకసారి రాంగ్ఫుల్ కన్ఫైన్మెంట్ అంటాడు, ఒకసారి బోత్ అంటాడు. యాజ్ పర్ ద బార్ ఎగ్జామ్ కీ. Since A has prevented Z from proceeding beyond certain subscribing limit, both offences are made out. Although in practice he is convicted of more serious wrongful confinement. Okay, BNS equivalent 126 wrongful restraint, 127 wrongful. BNS carry these offences forward. Actually, the wrongful confinement stronger చూస్తే. Okay, we'll move on to the next one, which is X intentionally pulls a woman's wheel without her consent, intending to annoy her. As per the Indian Penal Code, which of the following offense has been committed? Moving on, that is basically criminal force. Assault, as he didn't touch assault, just wheel pull చేసాడు కదా, హర్ట్ చేయలేదు, గ్రీవియస్ హర్ట్ చేయలేదు, అసాల్ట్ చేయలేదు, so it must be criminal force. What punishment is prescribed under Indian Penal Code 1860 for a person whom meams any minor, imprisonment for life and fine? Bharatiya Nyaya Sanhita considers force to be criminal force when it is intentionally used without consent, causing injury, fear, and annoyance. So it is intentionally without consent to causing IFA is important. So the answer is C. Multiple times వచ్చాయి. I'll just remove it. See. Next, Amit, intending to cause the death of Vijay, attacks him with knife. Vijay sustains several injuries and dies on spot. The investigation reveals that Amit acted with the knowledge that his actions were likely to cause death. However, there is no evidence of premeditation or intent to murder Vijay. So, each of the following offenses did Amit committed? Did he commit murder, culpable homicide, causing death by negligence, or voluntary causing grievous hurt? So the answer is culpable homicide not amounting to murder, since Amit acted with knowledge that his actions were likely to cause death, but without premeditation or intent to murder. Okay. So he knew that his actions would kill him, but he didn't have pre-planned intent to kill him. అందుకని అది culpable homicide. Okay. Next, punishment for rape in cases where the victim is a woman below age of 16 or 12 is included in which of the BNS? సో ఇలాంటి క్వశ్చన్ అడిగినప్పుడు ఏం చేయాలంటే మనకు తెలియనప్పుడు బిఎన్ఎస్ది ఓపెన్ చేసి సెక్షన్ 64 65 63 72 ఎత్తుక్కోవాలన్నమాట. ఎదుక్కున్నప్పుడు ఉమెన్ గురించి దేంట్లో ఉంటే అది ఆన్సర్ చేయాలి. A new offense of snatching has been introduced in BNS. Which section is it?
సార్ కొన్ని డబుల్ డిజిట్ ఉంటాయి, కొన్ని ట్రిపుల్ డిజిట్ ఉంటాయి కదా. హోల్ వి హావ్ టు రిమెంబర్ అట్లీస్ట్ ఫ్యూ కదా.
యా, సో అంటే ఇప్పుడు ఇక్కడ 4 ఇచ్చారు కదమ్మా.
No, so for example, it is 65. Suppose something is like 300. మీన్ అంతైనా మనకి రేంజ్ అయినా తెలిస్తే బెటర్ ఏమో అనుకుంటున్నాను.
అంటే ఫర్ ఎగ్జాంపుల్ ఇప్పుడు ఇందులో 4 సెక్షన్స్ ఇచ్చారు కాబట్టి యూ కెన్ జస్ట్
యా
అవి
యా యా
సెక్షన్స్
యా
పక్క
యా
పక్కనే
దట్స్
ఉన్నాయి కదా.
దట్స్ కరెక్ట్.
అండ్ ఈ సేమ్ థింగ్ స్నాచింగ్ కూడా సెక్షన్స్ పక్క పక్కనే ఉన్నాయి,
యా యా
304538. సో యూ జస్ట్ ఓపెన్ ద బుక్ అండ్ దిస్ ఇస్ లైక్
3040. ఓకే.
ఎక్కడ స్నాచింగ్ ఉంటే అక్కడ.
అవును కరెక్ట్.
అంతే, ఇన్ని సెక్షన్లు ఏడ గుర్తుంటాయి మనకి. మెయిన్ ఏంటంటే కేసెస్ గుర్తుండాలి. నెక్స్ట్ అవి లాటిన్ వర్డ్స్ ఉంటాయి కదా,
అవునవును అవును.
అవి లేవు, బేర్ యాక్ట్స్లో లేవు కాబట్టి దోస్ ఆర్ థింగ్స్ విచ్ వీ షుడ్ రిమెంబర్. ద కేసెస్ అట్లీస్ట్ వీ షుడ్ రిమెంబర్.
కేసెస్ వి షుడ్ రిమెంబర్.
గివెన్ బిలో ఆర్ 2 స్టేట్మెంట్స్, వన్ లేబుల్డ్ అసర్షన్. ఇది లాస్ట్ ఇయర్ నుంచి ఇది స్టార్ట్ చేశాడు, అసర్షన్ ఉంది అండ్ అదర్ వన్ ఈజ్ రీజన్. అని చాలా టఫ్, అంటే చాలా మంది ఎగిరిపోయారు, 60% పాస్ అయ్యారు బికాస్ ఆఫ్ దిస్. బికాస్ మోస్ట్ ఆఫ్ ద పీపుల్ స్టడీ ఇన్ హిందీ ఆర్ తెలుగు ఆర్ సంథింగ్ కదా. అసర్షన్ అంటే ఏంటి, రీజన్ అంటే ఏంటి, వాళ్ళకి పాపం అర్థం కాదు కదా.
కరెక్ట్.
So the BNS 2023 prescribes a death penalty for certain forms of gang rape. That is assertion. What is the reason? The purpose of this provision is to make all sexual offences non-bailable. In the context of above assertion, which of the following is correct? So basically the first ఏంటంటే గ్యాంగ్ రేప్లో డెత్ పెనల్టీ ఉంటుంది అని బిఎన్ఎస్లో చేశారు. ఇది ఎందుకు చేశారంటే మేక్ ఆల్ సెక్షువల్ అఫెన్సెస్ నాన్ బెయిలబుల్. సో అంటే దిస్ ఈజ్ నాట్ ద ఇంటెంట్. So A is true, but R is false. The assertion is true, but R is false. The purpose is not to make all of sexual offenses non-bailable, but specifically to provide enhanced punishment for severe cases. So that was the intent. Okay, so we'll move to the next topic, which is basically offenses against property. Offenses against property. First ఏంటంటే theft, section 378. Theft, whoever intended to take dishonestly movable property out of the possession of another person without the person's consent. Section 379, punishment for theft, up to 3 years, fine both. And section 410 of 2, criminal misappropriation. Whoever dishonestly misappropriates or converts to his own movable property is criminal misappropriation. A finds a purse with money not knowing to whom it belongs. He afterwards discovers it belongs to B and appropriates to his own use. Criminal misappropriation. Next, mischief. Whoever with the intent to cause wrongful loss or damage to the public of any person causes destruction of property. Next, A causes cattle to enter the field of Z, intending to cause wrongful loss to Z. That is mischief. Extortion with a threat of defamatory, threaten to publish a defamatory libel in order to extort money. So this is aggravated extortion, punishment imprisonment up to 3 years or fine or both. Next, to house trespass with intent to steal, house breaking. So criminal trespass, house trespass after preparation of hurt. So section 458, lurking, house trespass, house breaking in order to commit offense. Amit and Rani break into house at night with intent to steal using a crowbar to force entry. House trespass with intent to commit theft. Next, question 1. A causes cattle to enter upon the field belonging to Z, intending to cause and knowing that he is likely to cause damage to Z's crop. A has committed what? Intentionally crop మీద పంపించాడు కాబట్టి ఇది మిస్చీఫ్ అన్నమాట. X threatened to publish a defamatory libel concerning Y unless Y gives him money. Which of the following punishment may be given to X to the acts committed by him as per Indian Penal Code? Imprisonment up to what? So important thing ఏంటంటే ఇది నీ మీద ఏదైనా పబ్లిష్ చేస్తాను, నువ్వు నాకు డబ్బులు ఇవ్వు, దానికి ఏంటంటే అప్ టు ఇంప్రిజన్మెంట్ అప్ టు 3 years అండ్ విత్ ఆర్ వితౌట్ ఫైన్. 3 years గుర్తుంచుకోవాలి. అండ్ దిస్ ఈజ్ అండర్ సెక్షన్ ఇందాక చదివాం మనం, ఎక్స్టార్షన్ టు థ్రెట్, ఇది సెక్షన్ 383. నెక్స్ట్ సో ఫర్ ఎగ్జాంపుల్ ఇట్లాంటి క్వశ్చన్ అడిగారు అనుకోండి, డిఫమేషన్ లైబెల్ క్వశ్చన్ అడిగినప్పుడు మనకి మొత్తం బుక్లో ఏ సెక్షనో తెలియదు మనకి. సో in order to look at the section and then look at what we should be able to scan through and figure out.
In such cases, we have to, I don't know what will we do.
Yeah, because ఆ సెక్షన్ తెలిస్తేనే దెన్ ఇప్పుడు మనం 380 and 383 అని తెలిసింది అనుకోండి, then we can go and see which how many years.
అవును.
So according to the provisions of Bharatiya Nyaya Sanhita, the right of private defense or property extend to voluntary causing of death of another, any other harm to the wrongdoer in which the other offenses committed or attempt to be committed. సో ప్రైవేట్ డిఫెన్స్ ఎప్పుడు ఉంటుంది, ఇన్ ఏ క్రిమినల్ కేసెస్లో ఉంటుంది అని అడుగుతున్నారు. సో రాబరీలో ఉంటుందా, హౌస్ బ్రేకింగ్ ఆఫ్టర్ సన్సెట్, థీఫ్ మిస్చీఫ్ ఆర్ హౌస్ ట్రెస్ పాస్? సో ద ఆన్సర్ ఈజ్ 1 and 2 both. Just see. It is not రాబరీ, హౌస్ బ్రేకింగ్ ఆఫ్టర్ సన్సెట్. రాత్రిపూట హౌస్ బ్రేకింగ్ చేసినా, రాబరీ చేసినా, థెఫ్ట్ మిస్చీఫ్, ఇప్పుడు వాడు పొలాల్లోకి యానిమల్స్ పంపించాడని వాడిని వెళ్ళి చంపేయలేము. థెఫ్ట్, మిస్చీఫ్ ఆర్ హౌస్ ట్రెస్ పాస్, ఈ 3 వాటికి వాలంటరీ కాజింగ్ డెత్ ఇన్ సెల్ఫ్ డిఫెన్స్ నాట్ అలౌడ్ అన్నమాట. Amit and Rani decide to break into a house at night with the intent of stealing valuables. They use a crowbar to force open the door, but before they take anything, the owner of the house, Vikram, unexpectedly arrives home. Amit and Rani panic and run away without stealing anything. The police arrest them the following morning based on a complaint about Vikram. Which of the following offenses Amit and Rani have committed? So basically what they have committed is attempted to commit theft, house trespass with the intent to commit theft, attempt to commit robbery and burglary. So answer is house trespass. So first ఏంటంటే they have also forced the LRU and they had an intention to do theft. Since they use criminal force, they constitutes housebreaking with intent to commit theft, not mere attempt to commit theft. Okay. Next, A finds a purse with money not knowing to whom it belongs. He afterward discovers it belongs to B and appropriates to his own house. A is guilty of what? So A finds a purse, then he knows that it is basically it belongs to B. అయినా వాడు ఉంచేసుకున్నాడు. దాన్ని ఏమంటారంటే క్రిమినల్ మిస్అప్రోప్రియేషన్ అంటారు. So it is section 403. A finds the purse. So okay, all this is fine. Next, IPC has replaced the Bharati Nyaya Samiti. 403 criminal misappropriation is BNS 314. 405 IPC is criminal breach of trust. 316 is breach of trust. Theft 378 has become 303. Cheating 420 has become BNS 318. Next offense is related to documents and evidence, forgery. Section 463, forgery, making a false document or false electronic record with intent to cause damage or to commit fraud to cause any person with the property. Okay, 464 is making a false document. Forgery, making a false document. Next, section 192, fabricating false evidence, causing many circumstances to exist or making a false entry into book of record, intending that such circumstances appear in evidence and cause a fact to appear. Fabricating false evidences. Writing a letter in intimation of the handwriting purported to be confession of a murder. Section 192. Okay. Z handwriting లో రాసి నేనే మర్డర్ చేసిన పంపించడం is fabricating. సో దానికి కూడా పనిష్మెంట్ ఉంటుంది అన్నమాట. నెక్స్ట్ మ్యాక్సిమం ఫైన్ ఫర్ కౌంటర్ఫీట్ కరెన్సీ డాక్యుమెంట్స్ సెక్షన్ 182. Maximum fine for making or using a document that resembles a currency note or blank note. Okay, 300. for making or using a document that resembles a currency note or bank note. It's only 300 ena. Counterfeit currency is 300. Okay. And questions. Important 1920 important. So you should always look at AIB 19 and AIB 20 questions. ఎందుకంటే దాని లెవెల్ క్వాలిటీ చాలా పెంచేశారు క్వశ్చన్స్. So according to BNS, what is the maximum fine for making or using a document that resembles a currency note or a bank note under section 182, which is basically 300 rupees. ఇప్పుడే చదువుకున్నాం అది. Section 463 of the Indian Penal Code deals with the crime of what? 463 is here, forgery. 464 is making a false document. With the intention of causing Z to be convicted in criminal conspiracy, writing a letter intimating Z's handwriting. What handwriting చేసి రాసి forge చేస్తే that is nothing but fabricating false evidence, which is section 192. Next, offenses against marriage, which is basically matrimonial cruelty, section 495A. Husband or relative of husband subject a woman to cruelty. Cruelty includes any willful conduct likely to drive the woman or suicide. Harassment with the view of coercing her to meet unlawful. The heavily litigated based on arrests that led to Arnish Kumar. So 498A is basically domestic violence, maternal cruelty. దీనికి చాలా గైడ్ లైన్స్ వచ్చాయి ఇవి వచ్చాయి బికాజ్ హెవీ లిటిగేషన్ అయిపోయింది కాబట్టి అందులో. ఓకే, గైడ్ లైన్స్ సేఫ్ గార్డ్స్ ఇచ్చారు అర్నీష్ కుమార్ కేసులో. అండ్ this 413 is defamation. Defamation is basically whoever by words, signs, or visible representation makes or publishes any imputation concern any person intended to harm or knowing it will harm the reputation of such person. Okay, 10 exceptions is truth in public interest, fair comment on public conduct of public servants, report of court proceedings, fair criticism of published works. Next to section 500 is punishment for defamation. So 499 is about definition of, 500 is about punishment. Extend to 2 years or fine or both. Next, punishment for defamation and Indian is simple imprisonment for a term which may extend up to 2 years. Criminal intimidation, 503, threatening another person with injury to her person, reputation, or property. 504 is intentional insult with intent to provoke breach of peace. 504 statements causing public mischief. 506 punishment for criminal intimidation. Criminal intimidation is explained from 503 to 506. And 506 is compoundable offense under section 320 without courts without court permission. 506 punishment for criminal intimidation is basically they're treating it as a compoundable offense, which was asked in exam whether it is compoundable or kada in criminal intimidation. Okay, so criminal intimidation and explained under IPC under how many sections? It is 3 sections, 503 to 506. Equivalent of BNS will be BNS 351 to 352. And attempt and a punishment for attempting to commit offenses punishable with imprisonment for life or imprisonment. Imprisonment 1.5 for longest time provided by the offense. Attempt under BNS 20 section 62, punishment for attempting to commit an offense punishable with imprisonment up to 1.5 of the longest term provided by offense. So if a person attempts to offense punishment with maximum 10 years in prison, the punishment is 5 years. Okay. Next is C40 4.15 is so exam tips is basically about attempt అని ఒక టాపిక్ ఉంది 511. So if you're attempting and if you're not committed the crime, అది section 51 IPC, which is section 62 of BNS అన్నమాట. Maximum punishment attempt ki 5 years. 10-year offense కి maximum attempt to murder or 10-year punishment కి 5 years ఉందన్నమాట. Okay. If a person attempts an offense punishable maximum 10 years, what is the maximum punishment that can be imposed in section 62 of BNSS? Last year అడిగారు ఇది, which is basically 5 years. Maximum 1/2 of the longest term of the 1/2 అంటే 5 years. So this is basically a table which is punishments ఏంటి section 53 IPC లో ఉంటే section 4 of BNSS 5 types of punishments ఉంటాయి. Next, life imprisonment 20 years, so section 57, section 5, solitary confinement, section 73, section 11, 12, in maximum 14 days of solitary confinement ఇవ్వాలి. Extra territorial section 4, section 1 retained. Infancy insanity is retained and only sedition is changed. So if you look at almost all of them are retained. And rape ఏంటంటే ఇది గ్యాంగ్ రేపు మైనరు యాడ్ చేశారు. రెస్ట్ థెఫ్ట్ ఎవ్రీథింగ్ ఇస్ ద సేమ్. ఓకే, సో బిగ్గెస్ట్ చేంజెస్ ఏంటంటే సెడిషన్ ఒకటి, రేప్ ఒకటి ఎన్హాన్స్ చేశారు. అదర్వైజ్ ఆల్ ఆఫ్ దెమ్ ఆర్ ద సేమ్. దిస్ ఇస్ ద కంపారిజన్ ఆఫ్ BNSS key sections versus IPC. సో ద న్యూ ఇన్నోవేషన్స్ ఏం చేశారంటే ఆర్గనైజ్ క్రైమ్ ఒకటి సెక్షన్ 111, 113 టెర్రరిస్ట్ యాక్ట్స్ పెట్టారు, 152 రీప్లేసింగ్ సెడిషన్, 304 ఈ స్నాచింగ్ ఒకటి ఇందాక మనం డిస్కస్ చేసాం, 304 యాడ్ చేశారు. సెక్షన్ 70 డెత్ పెనల్టీ ఫర్ గ్యాంగ్ రేప్. ఓకే, నెక్స్ట్ విల్ గెట్ ఇన్ టు దీస్ ల్యాండ్మార్క్ కేసెస్. ఐ థింక్ దెర్ ఆర్ like 5 or 6 of them. First one is Melville J. Reg versus Govinda, 1876, distinguished between culpable homicide from murder. This was a landmark case which talked about culpable homicide versus murder. Next case, R versus Dudley and Stephens, says necessity not a defense to murder, killing innocent to save own life. This was basically in Hemaligar Chadwar. This was about the guy who was in ship, and since they didn't have any food, they killed him and ate him. They said it is necessity. So necessity is not a defense to murder అని ఈ కేసులో చెప్పారన్నమాట. And then Rupa Bajaj versus KP Gill held guilty under 354, which is basically outraging modesty of a woman, not an IAS officer. She is an IAS officer, but it is outraging modesty of a woman. So next, State versus Nalini, Rajiv Gandhi assassination case, analysis of criminal conspiracy and abetment. సో క్రిమినల్ కాన్స్పిరసీ అబెట్మెంట్ గురించి ఇందులో డీటెయిల్గా చెప్పారు అన్నమాట. నెక్స్ట్, వామ్ బత్ కరీ వర్సెస్ యూనియన్ ఆఫ్ ఇండియా. సో ఇందులో ఏంటంటే సెడేషన్ కేసెస్ అన్నీ పెండింగ్లో పెట్టేశారు 2013లో, సారీ 2022లో ఐ థింక్. దెన్ రీసెంట్ మన బిఎన్ఎస్ వచ్చినప్పుడు సెడేషన్ తీసేసి వేరే పెట్టారు అన్నమాట. Next, Bachchan Singh versus State of Punjab, death penalty unconstitutional, rarest of the rare doctrines. So in the death penalty, rarest of the rare crime అయితేనే చేయాలని ఈ బచ్చన్ సింగ్ కేసులో చెప్పారనమాట. నెక్స్ట్, మచ్చి సింగ్ versus State of Punjab, elaborated rarest of rare with 5 categories. ఇందులో మళ్ళీ దాన్ని ఎన్హాన్స్ చేసి 83లో 5 categories ఇచ్చారు. నెక్స్ట్, నానావతి versus State of Rajasthan, grave and sudden provocation exception to murder, last jury trial in India. So grave and sudden provocation. Nanavati case. Anybody knows what Nanavati case is? Only mode coordination. State of Maharashtra versus Mayor Hans George, extraterritorial jurisdiction, strict liability, ignorance of law, no excuse. So నాకు law తెలవదు అంటే it's not an excuse అన్నమాట. So this is where these cases are. And I think this is like topic coverage ఇచ్చాము. What are the provisions? Extraterritorial jurisdiction, punishment, BNS, general exception, abetment, conspiracy, public tranquility, public servants, homicide, child offenses, acid attack, And then BNS is low. What are the new things? Okay. So if you look at the serial numbers, if you look at IPC section 3 extraterritorial jurisdictions గురించి 53, 57 punishments. Next, general exceptions of punishment 76, 106, abatement 107 to 120, criminal conspiracy 120 లో ఉంది. Offenses against state, typical offenses against state section 121 and 124, and then public tranquility section 140, 141 to 153. Next, public servants మీద కేసులు వేయాలంటే 212, 216, homicide is 299 నుంచి 304 దాకా మల్టిపుల్ థింగ్స్ ఉంటాయి. చైల్డ్ offenses start at 315 అండ్ మ్యామింగ్ ఒకటి 363లో ఉంది. యాసిడ్ అటాక్స్ 326, మోడెస్టీ ఫోర్స్ అండ్ 339 దాకా ఉన్నాయి. ఓకే, ఈ బిఎన్ఎస్ తీసేస్తే మళ్ళీ ప్రాపర్టీ offenses 378, డిఫమేషన్ 499, criminal intimidation 503, and attempt is 511. So more or less, if you know this structure, you can look in the book and search in those sections. Okay. Okay. So there ends the third topic, actually fourth topic, which is basically the IPC and BNS. So the next topic we can do is Indian Evidence Act. Indian Evidence Act, do you want to do it tomorrow? Because there's nobody today.
Yeah, no problem, sir. I wish.
Yeah. Yeah. So we'll do it tomorrow. Maybe we'll get some people. So, but these 4 topics, 5 topics kalpte meeku 60% of the marks vastayi annamata.
Oh, okay.
First 5 topics.
So constitution, then
CPC, Civil Procedure Code.
CRPC and IPC.
Yeah. And then Indian Evidence Act, BSA.
అదే అన్ని ప్రాక్టికల్ సబ్జెక్ట్స్.